Hello everyone, welcome to another episode of this particular video. By name, I am Japhet Okaka Ebosetale. So for today, under civil procedure, we are going to be looking at preliminary considerations before instituting an action in court. Preliminary considerations before instituting civil matters in court. That's the topic we are going to be taking today under civil procedure. But first and foremost, what is civil procedure? Civil procedure, by name civil procedure, civil procedure simply means the method of commencing, conducting and concluding civil trials in the court. That's the meaning of civil procedure. But for today, we are here to look at preliminary considerations before instituting an action in court. Now, by the words preliminary considerations before instituting an action in court, it simply means these are the things that you must consider before instituting civil matters in court. It simply means these are the considerations. These are the considerations you must make before approaching the court, before undertaking litigation. These are the considerations you must make. This is why it is called preliminary considerations. Preliminary considerations before, not after, before instituting civil matters. Now, for this particular topic, there are some preliminary considerations you must make, which we are going to be looking at in this particular video. Now, the considerations include: you have to look at whether or not there is a reasonable course of action. You have to check out for pre-action notice and condition precedents. Pre-action notice and condition precedent. You have to look at whether or not the plaintiff has a reasonable locus standi. You have to look at the venue, limitation period, cost of litigation, alternative dispute resolution, immunity, and several others. So we are going to be looking at them one by one. So now we'll begin with course of action. Now, what is course of action? Course of action simply means the reason why the plaintiff is instituting an action against the defendant. This is why it is referred to as course of action. Course of action. Why are you bringing this action in court? Course of action. Now, there are several judicial authorities to this effect. There are several cases whereby the court defined the meaning of course of action. Now, let's look at them. So, first of all, begin with the case of Oko versus AG and Ebonyi State. The case of Oko versus AG and Ebonyi State, where course of action was defined by a court. Now, the court defined the phrase course of action to connote the totality of all material facts. You see that word facts, the totality of all material facts necessary to establish a legal right in a particular case. That was how the court defined course of action, as the totality of all material facts, the facts that happened, the reason why the plaintiff is approaching the court, the reason why the plaintiff is bringing an action against the defendant. It is those facts, the totality of all material facts necessary to establish a legal right in the case. That's the way the court defined course of action as. Then we also look at the case of Igbe versus Ade Farasin. Where the court defined course of action as a factual situation, the existence of which entitles one to obtain from the court a remedy against another person. A factual situation, the existence of which entitles one. So when these facts when these reasons are reasonable, when these facts are reasonable, it entitles one to obtain from the court a remedy. So course of action simply means the reason why the plaintiff is approaching the court for a remedy. Now, let's also look at the case of AG Federation versus AG Abia State. The case of AG Federation versus AG Abia State, where the Supreme Court in this case defined cause of action to mean the aggregate of facts which put together establishes or gives rise to a right of action. So it's this cause of action that gives rise to a right of action. So it's because of this reason that gives the plaintiff the right to bring an action against the defendant. It simply connotes the facts, it simply connotes the injury the plaintiff must have suffered, the harm the plaintiff must have suffered, the damages the plaintiff must have suffered, and all relevant facts. This is the simple meaning of cause of action, the reason for bringing an action, the cause of the plaintiff action. This is the meaning of cause of action. So for preliminary consideration before instituting an action in court, as a lawyer, when a client brief you with a case, they are just trying to let you know that you must first of all consider as to whether or not the plaintiff has a reasonable cause of action. This is why it is called preliminary consideration before instituting an action in court. A client has briefed you with a case, you must then look, is there a reasonable cause of action? What is the reason what is the reason for instituting an action in court? Is there a reasonable cause of action? You must look at the facts to check whether there is a reasonable cause of action before approaching the court. Now, we'll look forward. Then, for this particular cause of action, you will ask a question. If a plaintiff is instituting an action against, for example, 3 defendants, a plaintiff is instituting an action against 3 persons. So there are like 3 defendants, and for 2 defendants there is a reasonable cause of action, and for one particular defendant there is no reasonable cause of action. What will the court do? Will the court strike out the whole case, or will the court go on to proceed this? Will the court go on to proceed the case, since there is a reasonable cause of action for 2 defendants and there is no reasonable cause of action for 1 defendant? What will happen in this particular instance? Now, let's answer that question. Now, where there is a unreasonable cause of action against 1 defendant, but there is reasonable cause of action against the rest, there is an unreasonable cause of action against 1 defendant, but there is reasonable cause of action against the rest defendant. What will the court do? The main suit will be spared, and the name of the defendant without cause of action will be struck out. That's what the court will do. The defendant without a reasonable cause of action, the name of the defendant without a reasonable cause of action will be struck out. So it's not as if, due to the fact that there is a unreasonable cause of action against 1 particular defendant, then the court will just struck out the whole case. No, that's the name of that particular defendant will be struck out. So that's what the court will do. Now, this is it for cause of action. So as a lawyer, when a client briefs you with a case, you must consider as to whether or not there is a reasonable cause of action. So that is it. This is it for cause of action. Then we'll now go to the next preliminary consideration, which is pre-action notice and condition precedent. Pre-action notice and condition precedent. So as a lawyer, when the client briefs you with a case, what is expected of you is to check whether it is necessary to serve pre-action notice, especially when you are suing public bodies or public institutions. You must first of all look at whether it is necessary to serve pre-action notice. So this brings us to pre-action notice. Now, what is pre-action notice? So what is pre-action notice? So in the case of Aguma versus APC, the court stated that where a statute or rule of court prescribes a condition precedent to the assumption of jurisdiction, the condition precedent must be fulfilled before there is jurisdiction. So by the time it starts, you simply says that Mr. A, before you sue Dangote company, for example, before you sue this company, you must serve them notice that you want to institute this action against them. This is why it is called pre-action notice. You are informing them that you are giving notice to them that you are about to bring this action in court. This is why it know as pre-action notice. You are noticing them about an action that you are about to undertake, about an action that you are about to bring against them in court. This is why it is referred to as pre-action notice. So as a lawyer, you must consider whether it is necessary to serve pre-action notice on the defendant, and you must look for any condition precedent. Then we'll move forward. So for this pre-action notice, you will be faced with this question. You'll be faced with this particular question, like as we can see in section 17, subsection 2, paragraph E of the Constitution, which provides that the independence, impartiality, and integrity of the court of law and easy accessibility thereto shall be secured and maintained. You'll be now looking at this provision, a particular question comes to your mind. Now, the law is trying to say that before you institute an action against so and so, against this particular company, that the law says that before you institute an action against, you must inform them, you must give notice to them. But the Constitution, which is the grand norm, which is the fundamental law, is trying to say that easy accessibility to the courts shall be secured and maintained. Now, by giving notice to this company, does that not contravene this provision that says that easy accessibility to the court shall be secured and maintained? By giving notice to these people, which will take time, which will take expensive and the rest, by giving notice to these people, will that not contravene this particular provision? The simple answer is no. Now, this is what pre-action notice tends to do. Pre-action notice does not tend to limit your accessibility to court. No. Pre-action notice tends to do this. The intendment of pre-action notice is to give room for alternative dispute resolution and not to subvert justice. So that's what the purpose of pre-action notice is to do. It's not to limit your access to the court. No, it is just to give room. This is the purpose for pre-action notice. It is to give room to for alternative dispute resolution. So when Mr. A gives a pre-action notice to a particular company and look, I want to institute an action against you. I'm informing you, I want to institute an action against you. So it's not to limit the Mr. A access to court, but so that the company can look at should we resolve this? Okay, let's speak so that we can resolve this, so that there will be no need of going to court. That is the main purpose of pre-action notice. So as a lawyer, when a client briefs you with a case, you must check if it is necessary to actually serve pre-action notice. You must look at the defendant and then look at any relevant law, and then look at does the law says I must serve this defendant pre-action notice before I institute an action against them. So this is it for pre-action notice. Then for pre-action notice, we are now going to look at the status requesting pre-action notice in Nigeria. So in Nigeria, there are several statutes that says that before you institute an action against Mr. So and so, before you institute an action against this, you must do this, you must do that. There are several statutes in Nigeria that prescribe, that mandates a plaintiff to serve pre-action notice. And now we are going to consider those statutes. Now, the first is section 19, subsection 3 of the National Examination Council Act 2022. Section 19, subsection 3 of the National Examination Council Act 2022, which provides that before you institute an action against NECO, you must have served pre-action notice. This you can also see in the case of NECO versus Tokode in the case of NECO versus Tokode. So by this provision, it is mandated that before you institute an action against NECO, as a lawyer, you must serve pre-action notice. Now, that is the first one. Also, by the provision of Section 12, subsection 2 of the Nigeria Petroleum Corporation, Section 12, subsection 2 of the Nigeria Petroleum Corporation Act 2004, it is necessary before you institute an action against the Nigeria Petroleum Corporation, it is necessary that you serve pre-action notice. So these are the laws that mandate one to serve pre-action notice before instituting an action against this particular company and corporation. Even by section 72, subsection 2 of the Nigeria Ports Decree number 74 of 1999, it mandates that before you institute an action against the Nigeria ports, you must have served them pre-action notice. So the next question you are going to be faced with is, what are the contents of pre-action notice? What are the contents? Now, we have looked at before as a lawyer, by the time a client brief you with a case, you must check whether or not the plaintiff has a reasonable cause of action. You must check whether or not you are to serve the defendant pre-action notice. Now, the next question is, what are the contents of pre-action notice? Is it that you are just going to take a paper, you just write in the paper, pre-action notice, I want to institute an action against you? Is that how pre-action notice look like? That is the next question. So we are here to answer that. So for this particular question, this brings us to the case of Amadi versus NNPC. Amadi versus NNPC. Now, in this particular case, I'll be reading the facts. The appellant contended that his dismissal was contrary to the condition of service. The respondent objection was that the plaintiff failed to comply with section 12, subsection 2 of the NNPC Act. That's that particular section that provides that before you institute an action against them, you must inform them. So the defendant was like, the plaintiff failed to comply with this particular provision, in that no written notice of his intention to commence this suit, wherein the course of action, particulars of claim, relief claim, and the place abound of the plaintiff should be stated. Now, the High Court struck out the case on this score, and the appeal court and the Court of Appeal refused an appeal against the appellant. So in this particular case of Amadi versus NNPC, Amadi brought an action against NNPC, and you know that by the provision of section 12 of the NNPC Act, one is mandated to serve pre-action notice before instituting an action against them. And Amadi failed to do this particular Amadi failed to fulfill these particular obligations or this particular condition precedent. And for this particular reason, the High Court struck his matter out, and the Court of Appeal still rejected an appeal against Amadi. Now, for this particular purpose, you must note the content of pre-action notice. Now, look at what the courts look at some set content of pre-action notice as stated in this particular case of Amadi versus NNPC. Now, you must state the course of action. So when serving a pre-action notice against the defendant, the course of action, the reason why you are bringing an action against the defendant must be stated in the pre-action notice. So the course of action must be stated in the pre-action notice. Now, the particulars of claim must be stated in a pre-action notice. The relief sought. Now, you are instituting an action against the defendant, and before you institute that action, you have to serve them pre-action notice. Now, in the pre-action notice you are giving to the defendant, you must state the relief sought. you must state the remedy sought. You must state the relief sought. You must state the relief sought so that the defendant can like, okay, we have been given this pre-action notice, we can see the cause of action, we can see the particulars of claim, we can see the relief sought. So looking at this relief, instead of instituting an action against us, why not you come so that we can resolve this? This relief is something we can do. We can pay you this money for the damages that we have done. So this is why it is necessary to state the relief sought. And in this particular case of Amadi versus NNPC, the plaintiff failed to do so. Now, also, you must also state the place and bond of the plaintiff. That means the plaintiff resident. You must state the plaintiff resident in a pre-action notice. So these are the contents of pre-action notice. So it's not as if you are just going to write pre-action notice on a letter and serve it to the defendant. This content, these fundamental contents must be present in the pre-action notice. Now, we are done with pre-action notice. We'll now go to the next one, which is locus standi. The next one is locus standi. So locus standi simply means the capacity. Locus standi simply means the capacity and the rights of the plaintiff to bring an action against the defendant. So for this particular topic, as I will always say, which is preliminary consideration before instituting an action in court, as a lawyer, you must look as to whether or not the plaintiff has a locus standi. You must look whether or not the plaintiff has a standing, a legal standing, a legal right to bring this action in court. This is why it is referred to as locus standi. You must consider it is a preliminary consideration. Now, it's not as if you are serving a particular document. It is a preliminary consideration. It is a preliminary consideration. You must consider, does this plaintiff, does this man that is meeting me as a lawyer has the locus standi to appear before the court? Now, let's move forward. What is locus standi? This brings us to the case of Senator Adesanya versus President of Nigeria. Senator Adesanya versus President of Nigeria, whereby Bello JSC defined locus standi as the right of a party to appear and be heard on the question before the court or tribunal. So locus standi simply means the right of a party to appear before a court. It is the right of Mr. A to appear before a court. As a lawyer, you must consider that. So generally, for locus standi, by the provision of section 46 subsection 1 of the Constitution, is simply vests anybody that his fundamental human rights have been violated. The Constitution gives you the locus standi to institute an action in court. Let's look at the provision of section 46 subsection 1 of the Constitution, and it provides that any person who alleges that any provision of this chapter has been, is being, or is likely to be contravened in any state in relation to him may apply to a high court in that state for redress. So by the provision of section 46 subsection 1 of the Constitution, it simply gives everybody the right, the locus standi to institute an action in court as far as their fundamental rights has been violated. So locus standi simply means the right, the capacity of the plaintiff to institute an action in court. So as a lawyer, you must consider this. You must look at whether or not the plaintiff has the legal capacity, whether or not it is this man that is to bring this action, whether or not it is this man that is to institute an action. Let me illustrate this. If for example, Mr. A causes nuisance, to Mr. B. Now, Mr. A have caused nuisance to Mr. B. Mr. B has the locus standi to institute an action against Mr. A. But if Mr. C notices Mr. A causing nuisance to Mr. B and Mr. C institutes an action in court, it will be deemed that Mr. C does not have the locus standi to bring an action in court because he was not the one. He was not the one that his right or was violated. He was not the one. It was Mr. B. It is Mr. B that has the locus standi to institute the action in court and not Mr. C. It has nothing, the tortious act has nothing to do with Mr. C. So this is it for locus standi. As now going back, some students often misconstrue, some students often confuse locus standi for cause of action. Some students do confuse locus standi for cause of action. They take cause of action for locus standi and they take locus standi for cause of action. So there is a clear difference between cause of action, which is the reason why you are instituting an action against the plaintiff, and locus standi, which is the right, which is the legal capacity of the plaintiff to institute an action against the defendant. So there's a distinction between locus standi and cause of action. Now let's then look at the distinction between locus standi and cause of action. Now, locus standi focuses on the plaintiff, while cause of action focuses on the claim. Locus standi is looking at the plaintiff. It's like, does this Mr. A have the right to bring an action in court? Is it Mr. A that is to institute an action in court? Is it Mr. A that is entitled to this remedy? That is locus standi. It focuses on the plaintiff. It focuses on the individual. But cause of action focuses on the claim. Cause of action focuses on the claim. Cause of action look at the claim. Is this claim reasonable enough? Is this claim reasonable? Does this claim warrant a remedy? Is there a legal base? Does this claim contravenes anything? So cause of action focuses on the claim. It focuses on the harm. It focuses on the injury suffered. While locus standi focuses on the plaintiff. It focuses on the individual bringing the action. Now, a person may have the locus standi to bring a case, but lacks a valid cause of action. A person might have the locus standi. To bring an action in court, but he may lack a valid cause of action. The cause of action may not be valid enough. It may not be reasonable. It may be unreasonable cause of action. It may even fall under the rule of, that's the diminished principle, which is that the law does not deal with triviality. It may be an unreasonable cause of action. Despite the fact you have a locus standi, you might not have a valid cause of action. And vis-a-vis, you might have a valid cause of action, but you may not have a locus standi to bring that action. You might have a reasonable cause of action, but you may not have the locus standi to bring that cause of action. Now, we are done with cause of action. We are done with condition precedent and pre-action notice. We are done with locus standi. So the next we are going to be looking at is venue. We are now going to be looking at venue. So as a lawyer, when a client briefs you with a case, it is expected of you to look at the venue. It is expected of you to consider the venue. Why do you consider the venue? You consider the venue to know which court to approach to. You consider the venue to know which court to institute the matter. To know which court to approach, to know which court that you should go to seek a remedy. So as a lawyer, it is expected of you to look at the venue. Now, what is the venue? Venue is where the cause of action arose. Venue is where the dispute arose. Venue is where the court is situated. Venue is where the court is situated. Venue is where the defendant carries on business. Venue is where the defendant resides in. So this connotes venue. So you are going to look at the place the cause of action arose. You are going to look at the place the court is situated in. You are going to look at the place the defendant resides. You are going to look at the place the defendant carries on business. Why? To know which court has enough jurisdiction to hear this particular matter. So it is pertinent you consider venue. This is why venue falls under preliminary consideration before instituting an action in court. So that is it for venue. Now, the next preliminary consideration we are going to be looking at is limitation period. Limitation period. So for some civil action, yes, for civil action, there are limitation period ascribed to them. For civil action, there are limitation period ascribed to them, and we are going to be looking at that when we dive into this particular topic. So first of all, before approaching some examples of civil actions that are statute barred after some period of time, let's then look at the case of Merchant Bank of Nigeria versus Feteco. Merchant Bank of Nigeria versus Feteco Nigeria Limited. Let's look at this particular case and let's see the OD of the case of the court. Now, look at what the court held. The court held that the statute of limitation of action. The court held that the statute of limitation of action is designed to stop or avoid situations where a plaintiff can commence an action anytime he feels like. So that is the purpose of limitation period. So as a lawyer, you have to look what is the limitation period. When if for example, if Mr. A approaches you and look like so and so was negligent, so and so was negligent, you have to check, when did this thing happen? When did you notice this act? When did you notice this act? You have to look at this to know whether or not it is statute bad, to know whether or not you cannot bring that action again. That is why it is known as limitation period. It simply says that for this particular act, once you notice it, you have to bring this action within 3 years. For this particular act, once it happens, you have to bring that action within 2 years. It is referred to as limitation period. The limitation period is 3 years. After 3 years, you cannot bring the action again. It is statute bad. So as a lawyer, you must consider whether or not the client that is meeting you, whether or not his action is statute bad. But what is the purpose of this limitation period? As heard in Merchant Bank of Nigeria versus Feteco Nigeria Limited, the purpose of limitation period is to avoid the situation where a person can commence an action anytime it feels like. Somebody assaulted you, then you waited until 70 years before commencing an action. No, or for example, as a claim related to land, you must commence that action within 12 years. If you are contesting for land, depending on the state too, you must commence that action within 12 years. You should not wait, despite the fact that you know that this person is taking over my land. You do not commence the action. You did not do anything. You waited until 90 years time before you commence the action. No, limitation period is here to block that. It is here to bar that. It is here to stop the fact that any person can just commence an action anytime he feels like. So this is the purpose of limitation period. So as a lawyer, you must consider whether or not the client that is meeting you, whether or not his action is statute bar. Even equity, even in the Latin maxim that says vigilante bos no domitibus jura subvenit, which is that vigilante et non domitibus jura subvenit, which is that equity is the vigilant. Equity is the vigilant, and not those who sleep over their rights. Vigilante bos no domitibus jura subvenit. Equity is the vigilant. It is the vigilant, and not those who slept over their rights. So this is what limitation period came to do, to stop anybody for commencing an action anytime he feels like. Now, let's look at some limitation periods provided by law. Let's look at some limitation period prescribed by law. Is 3 years. For action related to damages for negligence, the limitation period is 3 years. You can see that in section 8, subsection 1 of the Limitation Act of Abuja, section 9 also of the Limitation Law of Lagos State. you can see that there. So for action related to damages for negligence, the limitation period is 3 years. After 3 years, you cannot bring the action anymore. Now let's look at another one. For action related to damages for slander, for action relating to damages for slander, the limitation period is 3 years. So if you are to bring an action for damages related to slander, for damages for slander, you have to bring that action within 3 years. After 3 years, the action is considered statute bar. This you can see in section 9 of the Limitation Act Abuja and section 10 of the Limitation Law of Lagos State. Now let's look at another one, which is action for recovery of land by the state. Action for recovery of land by the state. The limitation period is 12 years in Abuja and 20 years in Lagos. This you can see in section 15 of the Limitation Act of Abuja and section 16 of the Limitation Law of Lagos State. Now let's look at the last, which is action against public officers, is 3 months. So if you are to bring an action against public officers, the limitation period is 3 months, not 3 years, 3 months. So if you are to institute an action against public officer, the limitation period is 3 months. This you can see in section 2A of the Public Officers Protection Act. Section 2A of the Public Officers Protection Act. So if a client comes and meets you as a lawyer after studying preliminary consideration before commencing civil matters, you must look at, and the client say, I want to institute an action against this public officer. Now after studying this course, it is expected of you to look at the limitation period. Ask the client, when did this thing happen, to consider whether his action have been statute bar. Now this is it for limitation period. However, there are exceptions to the limitation rule. Yes, it is stated that if you are to bring an action against this is going to be statute bar after so time. Yes, it is so, but there are exceptions. There are exceptions to this rule. Now, what is the exception? Where the cause of action was fraudulently concealed, the limitation period will not apply. Where the cause of action was fraudulently concealed, the defendant fraudulently conceived the cause of action. You were not aware of it. Yes, the defendant have committed this act, but the plaintiff, due to the fact the defendant fraudulently concealed it, you were not aware of it. And after the limitation period, you were not aware of it. It is after 3 years, you are not aware of it. What this particular rule say that you can still institute an action against the defendant because it was fraudulently concealed. You were not aware of it. It was fraudulently concealed. Then this is an exception to the limitation rule. Now we are done with limitation period. Now the next preliminary consideration. The next preliminary consideration is cost of litigation. The cost of litigation is the next preliminary consideration. So as a lawyer, it is expected of you to consider the cost of litigation. You must look at the question, does it worth it? Is this matter too trivial to institute an action against? Is this matter too trivial? Is it too little? For example, somebody converted your biro and then you are bringing an action for conversion against the person. Now it's just biro. It's just a biro. It's just a pen. How much is it? So you must first of all consider the cost of litigation. You must consider. You must not be penny wise and pounds foolish, as they do say. You must not spend millions, thousands just for recovery this particular biro. So it is expected of you to consider the cost of litigation. You must consider how much am I going to pay? How much am I going to be paid? You must consider how much you are going to spend in the whole litigation process, in the documents you are going to photocopy, the document you are going to print, the document you are going to serve. You must calculate it, and you must also calculate how the remedy that is going to be awarded to you. You must also calculate the damages, the monetary value that is going to be awarded to you. So you must calculate all this. So it is expected of you when you are briefed with a case, and as regards this preliminary consideration before instituting an action, you must consider the cost of litigation. Now, after cost of litigation, the next preliminary consideration is alternative dispute resolution. Alternative dispute resolution is the next preliminary consideration you are to make. And there are different kinds of alternative dispute resolution. They include negotiation. Instead of approaching a court, you can just consider why is it not necessary? You must consider, is it not necessary that the plaintiff, the to be plaintiff and the to be defendant just come together and negotiate their differences instead of approaching the court. So it is expected of you to consider alternative dispute resolution, consider negotiation, consider mediation, consider conciliation. Why don't you just come and reconciliate? Why don't you just come and negotiate? Why don't we just go to arbitration? Why don't we just go to arbitration? Why don't you just go to multi-door courthouse? Why don't we just approach a multi-door courthouse? Why don't we just negotiate instead of approaching the court? So as a lawyer, you must consider this. Now, what is alternative dispute resolution? According to Black Law Dictionary define alternative dispute resolution as a procedure for settling a dispute by means other than litigation. As a procedure for settling a dispute by means other than litigation. Instead of approaching a court, you just negotiate by means other than litigation. There's no need to go into litigation. There's no need to go into litigation whereby you are going to spend a lot of money, whereby they are going to be grievances. In fact, the parties will even be angry at each other after the whole litigation. But by the time you go through alternative dispute resolution, the parties are no longer offended. They have negotiated their differences. They have agreed on something. They can still be friends. They can come back as friends. But going into litigation, they become enemies. They are angry at each other. And after spending a lot of money. So you must consider alternative dispute resolution. So we'll then move forward. As seen in section 15, subsection 3, paragraph D of the rules of professional conduct, it is expected that a lawyer must consider alternative dispute resolution as seen in Rule 15, subsection 3, Rule 15, subsection 3, paragraph D. It is expected that you consider alternative dispute resolution before approaching the court. So the next preliminary consideration we are going to take is immunity. Though sometimes this is taken as minor, but to me, not everything is minor. So as a lawyer, when a client briefs you with a case, it's just to say, I want to sue the president of Nigeria. So you know that you must consider, is the president of Nigeria not immune? Is it not immune? So it is expected of you to consider immunity. Who are you going to sue against? Do you stand a chance suing this particular person? So it is expected that you consider whether or not the defendant enjoys immunity. So as a lawyer, it is expected that you make such consideration before instituting an action against so and so. This you can see for immunity. You can see this in section 308 of the Constitution of the Federal Republic of Nigeria, and you can also see it in the case of Abacha versus Fawehimi, and Tinubu versus IMB Securities. So let's then go to the last preliminary consideration. You are to make, which is jurisdiction. In fact, this jurisdiction is so fundamental. So as a lawyer, you must look at the court that has competence to hear this particular matter. You must look at the court that has sufficient jurisdiction to try this particular case, as seen in the case of Bronick Motors Limited versus Wema Bank Limited. The court defined jurisdiction as the power of the court to exercise over a particular case, as the power of the court to exercise over a particular case of or course of action. A court of law can only exercise judicial power when it has jurisdiction. So without jurisdiction, a court of law cannot exercise judicial power, as seen in the case of Bronick Motors Limited versus Wellman Bank. So as a lawyer, you must consider whether or not this court has sufficient jurisdiction to try this matter. You must consider, you must make considerations. What court is competent enough to hear this particular case? What court is competent enough to try this particular matter? You must consider, you must make considerations. This is why it is referred to as preliminary considerations. Preliminary considerations before instituting a matter in court. Now, when does a court has jurisdiction? When does a court have jurisdiction? As seen in the case of Mandukolo versus Nkedimi, a court has sufficient jurisdiction to try a particular case when the court is properly constituted as regards the number and qualifications of judges. So when the court is properly constituted as regards the number and qualifications of judges, then that's one element. Then the court can have jurisdiction. Also, the matter or case you are bringing before the court must be competent enough to try such matter. For example, there are certain cases, there are certain monetary values, there are certain cases that you can go to the magistrate court, there are certain cases that you can go to the state high court, there are certain cases that you just go to the court of appeal. In fact, you just go to the Supreme Court. There are certain cases you go to the election tribunal. So you must consider which court has sufficient jurisdiction. Which court has sufficient jurisdiction to try this matter? Which court does this matter fall under? So you must consider that. Now, the next element, as listed in the case of Mandukolo versus Nkedimi, is that all condition precedents must have been met and followed. Now, the court must be properly constituted as regards number and qualification. The court must be competent enough to try the case and matter. Now, the case must have followed and fulfilled all condition precedents before the court can exercise jurisdiction. And we are dealt with condition precedent initially. So this is it for jurisdiction. So we are done with preliminary considerations before instituting an action in court. So let's go over it again. It simply says that under this particular topic, it simply says that you must consider whether or not there is a reasonable course of action. You must consider whether or not there is a condition precedent and whether or not there is a need to serve a pre-action notice. You must consider whether or not the plaintiff has a locus standi, whether or not the plaintiff has the legal capacity, whether or not he's the one to bring his action in court. That is locus standi. You must make such consideration. Then also you must look at the venue. Which court am I going to go? Which court am I going to go to? Where did this dispute arose? Where is the defendant located? Where does the defendant carry his own business? Where is the court located? Where did the cause of action arose? You must look at the venue. You must consider the venue. Also, you must consider the limitation period. Is the status, is this particular claim statute barred? Is this particular claim statute barred? You must make such consideration, preliminary consideration, before instituting civil matters. Also, you must consider the cost of the litigation. Does it worth it? Does it worth it? Penny wise, pounds foolish. Is this matter too small to go to the court for? Is it just because of this 100 naira barrel and to go to the court, then spend over hundreds and thousands of naira just for 100 naira barrel? No, you must make such consideration. You must look at the cost of litigation. Also, you must consider alternative dispute resolution. Can this particular matter or claim not be settled outside courts? Can't this matter just be settled through litigation? Can't this matter just be settled through mediation, through negotiation, through arbitration? So you must make such consideration. Also, you must look at immunity, and you must also look at, finally, you must consider the court that is competent enough to try that case which is jurisdiction. So this is it for preliminary consideration. Before instituting an action in court, you must make this consideration before approaching the court. You must make this consideration before seeking litigation. So this is it for preliminary consideration. As usual, by name, I am Japhet Okaka Ego Setani. Thank you so much for watching.